All right, it says that we are now streaming live. So good afternoon, everyone. This is the meeting of the Economic Matters Committee for February 3rd. We have a total of 4 bills today. The order will be, we are going to first take House Bill 585, which is been introduced by Delegate Deborah Davis, who I see on the screen. We will then go to House Bill 471, which has been introduced by Delegate Courtney Watson. We'll then go to House Bill 420, introduced by Delegate Wilson. And then the final bill we'll hear today is House Bill 642, introduced by Delegate Palakovich-Carr. So with that, I think we're ready to start. So Delegate Davis, the floor is yours.
Thank you, Madam Vice Chair and members of the committee. For the record, my name is Deborah Davis from District 28 in Charles County. I'm here to present Bill HB 585. And the problem is this: debt collection in our state is at an all-time high. Residents are left having to rely more and more on nonprofit agencies in the state for counseling and legal services. This problem has been growing long before thousands of Marylanders were struck with unemployment and the other financial hardships exacerbated by the pandemic. The need for counseling and legal services related to consumer credit and debt collection is growing, and mere education in these matters could save thousands of debtors in Maryland from having bench warrants issued against them and the potential for jail for debt. The solution, HB 585, establishes a fund to provide funding to nonprofits that help with counseling and legal services to consumers related to consumer debt and debt collection. The funding would be derived from assessing a filing fee paid by two collection cases filed in the District Court of Maryland. The fund will be administered by the Consumer Protection Division of the Attorney General's Office. I wish I could take credit for the brainchild of this bill, but this bill came out of the recommendations from the Attorney General Brian Frosch's recent COVID-19 Access to Justice Task Force. I'm happy to accept the Attorney General's support with the amendment to basically remove the entire fiscal note and allow the administrative costs to come out of the fund. In closing, thank you for your consideration. I respectfully request a favorable report on HB 585. Thank you.
Thank you very much. Questions for Delegate Davis? Delegate Pippy.
Delegate Davis, my friend, good to see you.
Good to see you.
There was a letter in there from the judiciary. I didn't know if you had a chance to see it. They had a couple, questions or concerns, and maybe you could address those. If you haven't seen it, I can share with you what they are.
Please share them. I have not seen them.
Okay, so it was really about administering the fund. They just said they weren't set up to do it.
Yep.
So I didn't know if...
I'm on Zoom. Can you take a message?
So
the technology these days. Yeah, so that was their concern, is that they didn't know if they were equipped to kind of manage the fund. I didn't know if there was something that you could work with them on, or if you had some thoughts there.
So the fund is, I don't know why it's confusing, but the fund is administered by the Attorney General's office. And it is, and in his letter, if you look at the Attorney General's letter, it even references the department. Consumer Protection Division of the Attorney General's office.
This is the collection of the filing fees. I apologize.
The collection of the filing fees?
Yeah.
I would love to talk to them about it. They collect filing fees on regular. Were they specific about it? I'm gonna
email it to you right now.
Thank you.
Yeah.
Appreciate it.
Thanks. Okay.
Delegate Ahrens is who I saw next.
Delegate Dumais, can I add real quickly that there are 2 witnesses? Do we do that before?
You want us to take your witnesses first?
However you prefer, Madam
All right,
Vice
who
Chair.
would you like us to call as part of your panel?
We have Marceline White, and
Mhm.
who is the second person? Give me a second. The organization, there's a representative from the organization called CASH.
Okay, all right, well, let's hear from Marceline White, and then we'll hear from Ms. McKinney, and then we'll go to questions.
Thank you.
Sure. Ms. White.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Marceline White, and I'm the Executive Director of the Maryland Consumer Rights Coalition, MCRC. MCRC advances economic rights and financial inclusion through research, education, advocacy, and direct service. We're here in strong support of HB 585 and thank Delegate Davis for bringing this bill. As noted, this implements a recommendation from the Attorney General's COVID-19 Access to Justice Task Force, which recognized the need to provide at least $2 million to financial counseling, debt counseling, and legal services organizations that are not funded through MLSE. There's separate mechanisms and bills that would fund MLSE. The reason being that debt collection is growing. Again, there's a disparate impact in debt collection in Maryland. A 2018 study found 43% of non-white Marylanders had a debt in collection, while only 19% of white borrowers did. Many of the organizations that offer financial counseling partner with legal service organizations, and this partnership is very positive. But there are lots of ways to address debt issues before it gets to the courts. These organizations provide a series of services that ensure that we are not overburdening the courts with a flood of debt collection cases by averting them upstream before it gets to the courts and saves the courts and the taxpayers money. Our demands have increased dramatically. You have my written testimony, but for example, we had 175% increase in demand for services over 2019. So this provides a mechanism. There was a California bill that passed in 2019 that is similar, that allocated $4 million for these kinds of financial empowerment and capability organizations. So this responds to the need. And ensures that there is a funding mechanism to implement the Attorney General's recommendations, which were signed off on by debt collectors, MSBA, a number of members of the task force all had to approve this recommendation, so it's widely supported, and will provide a stronger set of solutions to consumers, will help debt collectors by making sure people are paid on time, and will meet the need of the moment to provide this kind of resource for Maryland consumers. So for all of these reasons, we support HB 585 and ask for a favorable report.
All right, thank you very much. Ms. McKinney.
Madam Chair, members of the committee, my name is Robin McKinney. I'm the co-founder and CEO of the CASH campaign in Maryland. We're here in strong support of House Bill 585 and also thank Delegate Davis for putting this in. We were a member of the Attorney General's Access to Justice Task Force as well. Our organization provides a series of financial capability services, including free tax prep, financial education, financial coaching, financial planning, and screening for public benefits. We have seen in every service at least a 30% increase over the last year, and in some cases 150%, depending on the service, particularly for screening for public benefits. Our job works hand in hand with not just legal service providers, but actually with the debt collection industry and with lenders and financial institutions. Our job is to help people to get compliant, to get them to be able to pay their bills on time and to reduce their debt. In fact, the metrics that we judge ourselves on are just those things: on-time bill payment, ability to create savings, and ability to pay down debt. So we are a complement to this industry, which is a value add that is currently not paid for. So when you think about the funding source of putting a filing fee on debt collection agencies, again, this is a value add that we are providing to the industry and to lenders that currently they are getting for free. Most of the services that provide financial capability services are funded by private entities, whether it's by financial institutions or by private foundations. There are not government resources. And unlike legal services that are funded by the Maryland Legal Services Corporation, there's a gap for people that cannot qualify for those services, both financial capability services and the complementary legal services. Just as an example of how the demand is continuing to increase, we have started working very closely with the Department of Corrections to make sure that people who are re-entering into our society have a clean bill of health as they're entering society in the middle of a pandemic. And right now we're getting at least 200 referrals a month and sometimes more. In January alone, we had 13,000 phone calls for service to fill 200 appointments. The need is high, the funds are low, and for those reasons, we appreciate a favorable report on HB 585. Thank you for your time.
Okay, so now we'll have questions for Delegate Davis, Ms. White, or Ms. McKinney. And I said that I saw Delegate Arentz first.
Yes, you did, Madam Chair. Thank you so much for the time. A general question, I guess, for the delegate. You mentioned something about the collection of the fees. Those fees that are being collected already, where are they? Where's that money going to currently? Do you know?
I reference fees. I reference court fees in general are being collected by the court on a regular basis for filing fees for.
I guess my question is more towards, we're collecting them, we're using them now. This isn't a surplus of fees, is it? Are we going to be taking something from somewhere else is what I'm worried about.
No, it's not. It would be an additional fee and it would be assessed on each collection case that was filed.
Okay, so every collection case would have an increased thing. The other thing I wanted to ask you is I was reading through the testimony in Maryland Judicial Conference, Chief Judge Barbera kind of feels the bill is kind of onerous and doesn't know how they would implement it. Have you addressed those issues that they brought up?
I have not had the opportunity to speak with the Chief Judge.
Okay. All right. That's what I want to ask. Thank you so much. Thank you, Madam Chair.
Okay, Delegate Impalaria. You're on mute.
We will all figure this out eventually.
Oh.
So thank you, Delegate Davis. You mentioned that people could be jailed for not paying debts. And the only debts that I know that somebody could be jailed for not paying is that you didn't pay your fees to the state of Maryland with income taxes, or if you committed some kind of crime and you were supposed to repay that back. So could you give me examples of what you're talking about, that debts that people can be jailed for?
Absolutely. On the regular basis, the courts issue bench warrants for you if you do not show up or if you fail to answer interrogatories after a judgment has been entered against you. And usually the get out of jail fee is based on is set at the amount of the debt. So we are actually, it is pretty controversial. We're actually jailing people or actually keeping them in jail based on paying a debt.
And see, my understanding with that would be criminal charges that we're talking about, not civil. No one could be jailed for owing civilly money to, you didn't pay the rent, so you owed me the money civilly. You didn't finish paying for the car, so you owe me the money. You didn't pay for it. I have no knowledge of that being the case, that someone could be jailed for that. For criminal charges, yes, I would agree, but that's criminal charge. That's really not a debt that would be described as something else. And
unfortunately, Delegate, we've gotten around that, around the whole constitutional issue that you can't be jailed for debt. And the way we've gotten around it is you get jailed for contempt of court. So I've done collection work. What happens is after I get a judgment, I go back, I file requests for interrogatories. And if the person does not respond to those interrogatories, I go back to court and I ask for a bench warrant on for the debtor based on the amount of the outstanding debt. And courts routinely will give me a bench warrant. And the only way if the person is arrested, the only person they get out is they satisfy the amount of money that was established on the bench warrant. So it is done.
yeah, I'll have to look into that more.
Yeah.
I know you have a debt placed against you and you go to get a loan. The loan company will say, we're not going to give you a loan unless you pay off debt that's sitting there. And it has to be registered every so many years. And It's new to me that someone could be arrested or bench warrants issued for, basically you don't show up, you just don't have a judgment put against you. And so that would be new to me if that's the case. And thank you for bringing the bill.
I think that's a great example of why we need this bill, because the average citizen doesn't know that until it happens to them.
Thank you.
Thank you. Delegate Brooks.
Thanks, Madam Vice Chair. Delegate Davis, one of the two unfavorable letters came from the Maryland DC Credit Union Association. And they're opposed because there's that fee cannot be, collection fee cannot be passed on to the debtor. Yeah, and normally they're somewhat favorable toward their members, and they feel as though that this would add a significant amount of time and cost to them, and they've already exhausted their resources of trying to collect. So how would you address that concern?
Well, we felt that it would do a disservice to the debtor to add an additional fee to what they owe. Currently, the creditor can assess attorney's fees, court fees, other court fees, filing fees that they file when they actually file their lawsuit. So there's a host of other fees that they can charge. And we just felt that passing it along to the debtor just did a disservice to the debtor, just compiled the problem that already existed.
Would that not have an impact on the shares of the members of that credit union? Because there's a cost associated with that, and for an individual not, living up, honoring their financial obligation, and the cost you have to pay for that. So,
yeah, and with all due respect, there's a cost for everything. There's a cost for citizens not being able, going to jail for debt. There's a cost for the situation we're in with COVID-19 and people not knowing their rights. There is a cost. I think the cost is best borne by corporations who are in the collection business rather than the individual citizens.
okay, thank you.
Delegate Howard.
Mhm.
You're on mute, Delegate Howard. Sorry.
Sorry about that.
It's okay.
Thank you, Madam Vice Chair. Delegate, you said that one of the things that the court does is issue an FTA, and based on that FTA, if they clear the debt, then they're out of jail. So basically the bail or the bond, so to speak, would be the debt amount. Is that correct?
So when I'm in court, I can ask for the amount of the debt, and it's up to the judge to establish the amount, to agree to the amount that I asked for. And usually it's customary to ask for the amount of the debt as the bond to get out of jail.
Does the court take into account the financial situation of the defendant?
In my experience, that is not the case.
What happens to that person if they do end up going to jail, so to speak, or not so to speak, but if they do end up going to jail until they pay off the debt, essentially based on the amount the court has set, and they can't pay it?
In most jurisdictions, you get once you're arrested, you get your day in court. You get an opportunity to speak with the judge, but you're in contempt, and you could spend more time in jail.
How many people do spend more time in jail? Do you know?
I don't know.
Okay.
My experience has been when you go to court, most jurisdictions have a collection docket.
Right.
And there's hundreds and hundreds of lawyers, and not hundreds. There are 10 and 20 lawyers there. There are people lined up coming out of the door, and they have no counseling. You go sit down with the lawyer for the other side, and you get into an agreement, or you get on a different docket. And then there's a whole different docket for those who fail to appear or fail to answer interrogatories. And
yeah, I think that's a separate subject, though.
Yes, and it's routinely just issued the bonds are issued.
Is the defendant able to, when they're talking to these other attorneys, are they able to structure a debt settlement or settle the debt for a lesser amount or even the same amount? I mean, maybe they have a structured payment or something like that, because I can imagine there's a lot of people that just don't have the money to cough up $500 or whatever the amount may be, but they might be able to do $25, $30 a month.
Absolutely. In some jurisdictions, they have civil collection courts, and they have separated that docket from other dockets.
What if
not
these
throughout the state of Maryland?
Okay. What if these collection agencies collect these fees, but where applicable, waive these fees? Would you be open to an amendment that would allow them to waive these fees? Because I imagine some of them do waive these fees.
Well, I don't think we're solving the problem. We're about it. And of course, the problem is that we need to fund the agencies that that give help to the citizens. But
I guess what I'm trying to get at is that, are we trying to fund the agencies, or are we trying to help the citizens? So I want to make it so that the end goal here is to help the citizens. I appreciate funding the agencies, but I don't want that to be the chief priority.
So how are you suggesting we help the citizens by waiving the fee?
Well, that the companies would waive the fee, that they would, where applicable, they could show that they waive the fee.
Where are they getting the counseling though? I kind of missed that.
Okay. Well, that's something we can talk about. I mean, that's
sure
within the purview of your bill. That's not really something I would answer. But would you? Okay, we'll talk offline a little bit more.
I appreciate it. Thank you.
Thank you.
All right. I do not see any other hands for questions of Delegate Davis, Ms. White, or Ms. McKinney. So with that, we're going to move on to the next witness, Helen Reynard. I'm sure I murdered your name, but.
Not at all. Yeah, good afternoon, Delegate Davis and members of the committee. My name is Helen Reynard, and I'm the president and CEO of Consumer Credit Counseling Service of Maryland and Delaware, a nonprofit housing and credit counseling agency headquartered in Maryland since 1966. I am here today as well in full support of HB 585, as well as the request for an amendment that the Consumer Protection Division be allowed to use some of the funds to cover the administrative costs associated with managing this new fund. For 55 years, my organization has provided quality financial education, free budget and credit counseling, debt management solutions, and budgeting tools to tens of thousands of low and moderate income Maryland residents. We have done so in collaboration and through referrals with many other well-established and quality nonprofit providers, some of whom are present today. Last year alone, we served over 10,000 residents through individual services and general education. Our main sources of funding to this day are still corporate and foundation donations. We do not currently receive any funding from the state, and neither do the majority of the counseling providers who would benefit from this new service. We've talked a lot already about the impact of the COVID-19 pandemic, so I think I'm going to skip my remarks on that. However, I wanted to mention that we have too received and seen a significant increase in the demand of services. Since last summer, about 50% increase in our call volumes, and that represents 40 to 50 more residents calling us every day. With permanent issues and concerns. We are seeing a huge increase in referrals out to legal services right now. We're seeing people coming in more and more so concerned about bankruptcy, and that's really started to happen. We're starting to see a lot of that. I wanted to come back to the comment that Robin made about how complementary our work is really to the work that the creditors and the debt collection agencies do. I want to emphasize the fact that what we do is incredibly effective, not only in helping consumers, but also in helping creditors mitigate their losses. Some of the benefits of this comprehensive counseling that I think some people might be questioning, are very well documented. There's been a lot of studies in the past few years, and some of them include the reduction in the likelihood of foreclosing or filing by 70%. Increased likelihood to receive a loan modification, sustainable loan modification by 2.83 times. improved budgeting skills, often leading to increased disposable income of $200 to $300, as well as reducing the unsecured debt level, allowing people to reduce by themselves their unsecured debt level by $2,000 to $3,000. Increased ability to handle future financial shocks, improve confidence in negotiating suitable and sustainable financial product, increases in credit score, mitigating credit score loss, and of course, increased awareness of potential fraud and identity theft, which we haven't talked about, but very important. In conclusion, this bill really embodies the core of our mission and the mission of our partners. We urge you to move favorably on HB 585 and the proposed amendment submitted by the Attorney General's office. Thank you.
Thank you. Any questions for Ms. Reynard? Delegate Howard.
Thank you, Madam Vice Chair. Ms. Reynard, you said that you primarily receive donations to help run your organization. Is that correct?
Yes, we do. We also write a lot of grants. And we are lucky to also provide a lot of housing counseling that's funded through federal funding.
So you get some federal funding, some donations, and some grants. With the establishment of this fund, would you be eligible for state funding out of this fund?
Well, I hope that it would really help us. As I said, we've seen an influx of additional clients that currently we do not have funding, direct funding to support.
This would be essentially the establishment of another funding source for your organization. Is that correct?
Yes, that will primarily support Maryland residents, and especially those who have been impacted by COVID, long-term impacted.
Okay, thank you.
You're welcome.
Thank you, ma'am. Any other questions for Ms. Reynard? Seeing none, thank you for your testimony. And we will move on to Sarah Frush.
Hi, good afternoon.
Hi.
Thank you to Delegate Davis and members of the committee for your time. My name is Sarah Coffey Frush. I am the Executive Director at Civil Justice, and we are here in strong support of this bill. Civil Justice is a statewide legal services nonprofit, and most of those who seek our assistance neither qualify for free legal help, nor can they afford the fees typically charged by attorneys. For them, CJ is the only statewide legal services organizations providing free and affordable help. Due to the lack of representation in consumer cases, CJ has traditionally maintained a strong practice in consumer protection work. According to Pew Charitable Trust, between 2010 and 2019, less than 10% of defendants in debt collection cases have counsel, compared with nearly all plaintiffs. And according to studies in multiple jurisdictions, consumers with legal representation in a debt claim are more likely to win their case outright or reach an agreement with the plaintiff's attorney. This analysis is reflected in CJ's research about collection actions, as well as our representation of Maryland consumers. About this time last year, Civil Justice reviewed 100 cases filed between 2016 and 2018 in Baltimore City, where tenants were sued for alleged damages to a previous rental unit or unpaid rent. We found that the average judgment in those 100 cases was about $4,700. 45 of the 100 cases had already resulted in wage garnishments and bank account attachments, and 3 of the families had already filed for bankruptcy. With the generous support of the ABLE Foundation, we launched a program to provide representation to Baltimore City families sued by their former landlords. And in our first 10 months of work, and despite a dramatic drop in cases moving through the court system, CJ staff helped Baltimore City families avoid $56,000 in potential wage garnishments and bank account attachments. And that was just with a part-time staff attorney. And the help we provided not only included raising defenses, but it also included things that we're talking about today, negotiating settlements with creditors' attorneys, for example. Greatly limiting CJ's ability to assist more Maryland families is that we are largely reliant on private foundation funding to provide services to Marylanders sued for debt collection. For example, we do not receive MLSC funding, Maryland Legal Services Corporation funding. And while that allows us to help both low and moderate income Maryland families, it also means that we don't have that dedicated source of funding to rely upon. This would really inject organizations like the ones who are testifying today with much needed funding to assist Marylanders of both low and moderate incomes. And I'd encourage you to give this bill a favorable report. Thank you.
Thank you. Any questions for Ms. Frush? Delegate Aaron's.
Yeah, I'm skimming through the bill here, and what is the threshold to utilize these services? Like, if somebody goes to a collection agency, I'm not seeing where that is. As far as, could a person that owns 7 businesses get involved in a collection issue and utilize this fund?
So the fund, as I understand it, correct me if I'm wrong, is that when a debt collection case is filed, and you would have to identify which cases are within that parameter, then the fund would, based on the filing fee, there would be a $30 filing fee included that would go into a fund to fund organizations like the ones who are testifying today. So I think your question might be, what kind of cases are going to qualify for the fund? Is that right?
Yeah, how do you determine that? That's kind of where I was going with it. How do you determine, let's say, if a guy has living in a penthouse down in whatever city you want to call it, and he's got boats, cars, and all this stuff, but he has some bad debt in some area. Can he access this?
Could he access the services provided by civil
by
justice?
you all and get the coverage and utilize this, what the purpose of the bill is, to actually benefit from this bill?
So I can speak with respect to civil justice. Our in-house, we have both a in-house team as well as a network of attorneys around the state. For our in-house team, we will not provide representation for anyone who is over 400% of federal poverty level. So that would be the limit for civil justice.
Is that you, or does the bill prohibit it?
I don't
That's
know
you,
if the
right?
bill addresses it.
Delegate Aaron's, I could answer that.
Okay, thank you.
The bill simply assesses the cost and gives it to the Consumer Protection Agency. And the Consumer Protection Agency decides how to distribute the money. So the money would, it would depend on how the agencies that were funded. And if that's a concern, we could make it clear that the agency would only help people that were lower income, or we could put a number on it.
Okay, that's just a question. Thank you. Thank you, Madam Chair.
You're welcome. Any other questions for Ms. Frush? Seeing none, we will move on to the final witness on the bill, Mr. Stephen Sakamoto-Wango.
Thank you, Madam Chair, members of the committee. Steve Sakamoto-Wango from the Consumer Protection Division of the Attorney General's Office. Here in support of House Bill 585. We have requested an amendment, but we generally support the goals of this bill. As the sponsor and previous witnesses have mentioned, the Attorney General formed an Access to Justice Task Force to deal with issues arising out of the pandemic. And this was one of the recommendations of the task force, because the organizations that are involved, you provide important services to consumers that can, A, help them keep out of court in the first place by helping them get their finances in order, helping them address debts and resolve debts outside of court without having to face a debt collection lawsuit. And it provides an important, service to keep consumers out of court, which is something that we prefer to do as well. We try to educate consumers to the best of our ability, but we're not always able to get to them, and the organizations that would be funded through this bill do in fact provide those kinds of services. Just a note with respect to the body attachment issue, the Attorney General does have a separate bill that's dealing with that issue, is being heard next week in judiciary. So I'm not sure if that's the subject matter for this bill. The amendment that we have requested, right now, the fund can be used only for providing funding to nonprofit entities, provide counseling services, legal assistance to consumers related to consumer credit and debt collection. While the Consumer Protection Division does a lot of different things, right now we don't administer funds, we don't review grant applications, we don't issue grant funding. So we would require staffing to be able to do that. So we're asking the bill be amended to allow us to use part of the funding, to fund the positions necessary to administer it. In respect to one of the questions that was just asked, it does require that we adopt regulations that would set the parameters for who's eligible for the money and how they would apply for it. So we would urge a favorable report with the amendment that we've proposed. Be happy to answer any questions. If not, I need to run across the street to Senate Finance.
Any questions for Mr. Sakamoto Wengel? Seeing none, I believe that then concludes the testimony on House Bill 585. And I see the chairman is now here. We'll move to House Bill 471.
Good afternoon, everyone. House Bill 471, we have Delegate Watson with us. Delegate, could you get us started, please?
Yes, thank you, Mr. Chairman. House Bill 471 is a bill that we heard last year. We voted out of the committee and we voted out of the House, but it did not have enough time to pass the Senate, so it is back. And it is the Mother's Maiden Name Bill, which basically asks the Maryland state banks to provide an alternate security question other than mother's maiden name. This is one way the bill is different from last year in that instead of telling the banks you can't use that, the bill says we need you to offer at least 2 security questions. Because of that change made by the sponsor in the Senate, the Maryland bankers now are supporting the bill, and you have a letter of support in your files. There's a couple of you, or at least one of you, that wasn't here last year, so I will just briefly and for the public explain the bill. So the mother's maiden name is a security question that was first used in 1882, and it's outdated in today's digital world. People can find mother's maiden names easily on social media. It's also a question that's not applicable to everyone, and many women choose to keep their maiden names or hyphenate their names. It makes customers vulnerable to hacking, and the security questions and answers were among the data stolen from 1 billion Yahoo accounts in 2013. So that's just one example. Hyphenated names automatically expose the answer. Last year, I read some names, some maiden names that might sound familiar to the members on the committee, and I'm going to read them again because we have a new committee member who may recognize a name in this list. So these were the names that we found, our intern found, for all of you in about an hour last year. Hickey, Earp, Perez, Belazikian, Quatman, Malave or Malave or Malavi, I'm not sure how to pronounce it, but he knows who. Malave. And Flanagan, Hayjack, and Highland. So those are simple names that we found pretty quickly. Again, we passed it last year. This year, we even have the banker support. So I respectfully ask for the committee to support this bill. And hopefully this time it will be unanimous since we do have the banker support. We had a little mishap with the representative from the Bankers Association in signing up. So she's not with us, but she did submit her testimony. And we also have written testimony from Linda Mack of Global Investigative Services, among others. Thank you, Mr. Chair.
Good work, Delegate. Are there any questions?
Mr. Chairman.
Delegate Turner.
Thank you, Mr. Chairman. I just have a quick question. Is this only for the banks and not the credit cards and all? What is just for the banks only to not use mother's maiden name? Okay, because credit cards are asking you what when you apply for the credit card, the first thing they said, what's your mother's maiden name? Okay, so so are we just saying just banks and not the credit cards?
Yes, because we have authority to regulate the Maryland state banks only. And so that's the only thing it applies to. I did have to laugh though. I think when I was signing up for the COVID testing registry with the state, I asked for mother's maiden name.
They sure did.
So you're right. We have a long way to go, but this just regulates the Maryland state banks because that's what we have the authority over.
Oh, okay. Thank you. Just curious because it just happened. Okay, thank you. Thank you, Mr. Chairman.
Yep, Delegate Impalaria.
Can't hear you.
Just a little side note, you know, Social Security Administration asked for your mother's name. And when they ask for your mother's name and you tell them what your mother's name is, many times they'll look at you in fear because either you're a fraud or they now have to tell you that you're adopted. And at the federal level, that needs to be changed. It's pretty frightening because it happened to me. Fortunately, I knew my mother's real maiden name. So when I said Pastorio, the woman looked in fear and just, I said, doesn't say that, does it? It says Kelly, doesn't it? She said, yes, it does. I said, well, my mother's adopted. And then I looked at her and said, has that ever happened? Did you have to tell somebody that they were adopted? And she says, yes, it's not a comfortable situation. So, you know, the maiden name has a little bit of trouble. And I'm sure the same thing is with the state. They use the true mother's maiden name, not the adopted mother's maiden name. And that probably needs to also be changed going forward. So thank you.
That's really interesting. I didn't know that, Delegate.
Anyone else?
Delegate Wilson.
Delegate Wilson.
Mr. Chair, the little brown hand means that I was waiting in line.
I was trying to ignore you, but Delegate Dume wouldn't let me.
I just want to say, Courtney, thank you very much. I literally just went through this with the VA yesterday, and they were asking me my mother's maiden name, and I don't know who my mom is. So it's really awkward because there is no plan B in many of these locations if you don't know who your mother is, ergo you won't know her maiden name. So a lot of our foster children, a lot of people that grew up in the system are totally clueless when it comes to banks. Half the questions they ask, you can't relate to because you don't know your family, you don't know your past. So I appreciate this. So it was a good bill. Thank you.
That's a good point. And they could feel like that's almost a microaggression. So yes, that is another very good reason to sail this bill through the committee and the House.
Right. Seeing no further witnesses on the bill and seeing no further questions, we will declare the hearing for House Bill 471 to have been held. And so now I would like to go to Delegate Wilson for House Bill 420.
Thank you, Mr. Chair and colleagues. I promise I will be brief in this bill. This bill was brought last year to employer ex-offenders liability for negligent hiring and inadequate supervision. Colleagues, I brought this bill up. The reason it was brought back again was partially because I still find that we need a resolution. I understand there's some legal issues that have to be dealt with, but what we're trying to do is find a way for individuals who have been incarcerated, who've been prosecuted, convicted, and done their time, when they get back out, you know, I'm pro law and order like everybody else, but it gets very difficult. It feels like if you're a felon, once a felon, always a felon. No matter if it was 19 when you did it and you're now 50, you're still being held accountable. I was trying to find a way to put something in to allow these individuals to get jobs more comfortably. Some kind of mechanism that would preclude individuals from being sued if indeed the felon that they hired ends up recidivating. Again, I know this is not a perfect bill. I don't want to burden everybody with the time because I know we had this hearing last year. And I would hope over time we would figure out what we can do, because we need to do more to incentivize employers for hiring these ex-offenders. I don't want to see them on the streets, and we don't want to see them because everybody knows that idle hands do the devil's work. All this bill is trying to do was give our employers a little opportunities, or give our felons and ex-felons some opportunities here. Again, I already know the opposition because I heard it last year. I couldn't find another solution. I would love to hear some for a way to make this bill actually work. But you know the intent of this bill. I'm sure we're going to hear great opposition, but the goal really is to try and help our ex-offenders get reemployed. So that's my bill. I'm looking forward to some input on House Bill 420. Thank you.
Any questions for Delegate Wilson? Hearing none. Let me go to Sarah Price if she's with us.
Yes, thank you. Good afternoon, Chairman Davis and honorable members of the committee. My name is Sarah Price, and I am here on behalf of the Maryland Retailers Association in enthusiastic support of this bill. By providing immunity for employers who are seeking to hire citizens who have completed their term for an offense, this bill would create a more positive environment for those employees and would expand their opportunities for employment. We believe that this legislation would result in a decrease in recidivism rates in Maryland and would have a positive impact on our businesses and communities. So thank you for your consideration, and we urge a favorable report.
Any questions of Ms. Price? Seeing none. Corey Johnson.
Good afternoon, Mr. Chair and members of the committee. My name is Corey Johnson, and I am an attorney and the Senior Policy Research Analyst at the Job Opportunities Task Force. First, we would like to thank Delegate Wilson for House Bill 420. As our organization's mission is to eliminate barriers to meaningful employment and job opportunities, we fully support House Bill 420 and urge a favorable report. An interaction with the criminal justice system can be both a cause and consequence of poverty and an extreme barrier to meaningful employment for many Marylanders. Research indicates that with the rapidly expanding use of background checks, previously incarcerated job seekers are routinely excluded from consideration for jobs, even for minor offenses that occurred years ago. Many employers often refuse to hire or even consider qualified applicants with criminal records, even if the records reflect non-convictions. Further, Maryland currently allows criminal record information to be posted online, which means that an individual's criminal history is no longer strictly used for law enforcement purposes or sentencing, but hiring decisions. The Justice Policy Institute in 2015 reported that the state of Maryland spends approximately $17 million a year to jail people from the Sandtown, Winchester, and Harlem Park neighborhoods in Baltimore City, yet the unemployment rate in those areas is 22%. As unemployment and existence of a criminal record has shown to be inextricably linked, we believe that House Bill 420's elimination of liability for negligent hiring of a previously incarcerated individual is necessary. It further ensures that employers that are willing and interested in hiring workers with a criminal background have an opportunity to do so. Additionally, as an attorney, I would like to reassure the committee that this is already standard tort law practice in the legal field. House Bill 420 provides that extra blanket of security and surety for employers as it pertains to vicarious liability, but it will not drastically change civil law in the state of Maryland. I'll explain. House Bill 420 would not eliminate liability for an employer for the actions of their employees that are related to carrying out their job and related duties and responsibilities. It would only eliminate the criminal actions that fall outside of the scope of employment. And so for the reasons above, we urge a favorable report.
Thank you, Ms. Johnson. Any questions? Seeing none. Thank you very much. George Tolley. George Tolley. If not, James McAllister.
Yes, good afternoon, Mr. Chairman. Can you hear me?
Yes, sir.
Okay, technology is new to me. So anyway, first of all, on behalf of the Maryland Association for Justice and as a Marylander in general, I want to commend Delegate Wilson for identifying an important problem. it's our belief that this is the wrong answer to that problem. Negligent hiring, just so people understand it, means you sue the employer because the employer didn't exercise reasonable care in selecting an employee. And as a result, some unsuspecting customer or coworker, suffers an injury as a result of the employer's failure to take due care. So there's a number of problems with this bill. Number one is it takes away the right to compensation for people who have no idea that the employer has employed somebody who possesses a potential risk factor. And nor do the customers that deal with these people. And Delegate Wilson, I would propose the same thing I proposed in the Senate last year, which is insurance coverage with premium support. Because if anybody's ever been someplace where you've seen the sign that says for insurance purposes, what that would do is the insurance companies would enforce best practices to make sure that the employers applied the best practices to screen those who pose a risk versus those who don't pose a risk. And it doesn't bar somebody from employment if the employer identifies a risk. It just means they have to take reasonable precautions, meaning if they know somebody is potentially likely to be dangerous or poses a risk, they keep an extra eye on them. It doesn't preclude them from working. Number two, there's no deterrent factor. So in other words, the employer doesn't have to ask. The employer doesn't have to concern themselves and therefore puts people in the workforce with coworkers who have no idea what this person's background might be. Number three, there's no differentiation between crimes. So a rapist and a jaywalker, who have convictions for those are treated the same. And I suggest to you there's a different risk factor. Number four, it talks about industries. Well, the notion here is that somehow warehouse workers, truck drivers, are all these like big burly guys that can take care of themselves. Well, that's not true. My niece works for Amazon in a warehouse, and I don't want her working next to somebody unless the employer has asked the right questions and taken the right precautions. And lastly, the bill doesn't say, okay, why don't you warn your coworkers, and if the employer is going to avail themselves of this, warn the coworkers, we are not screening anybody who comes through the door, and we're not going to ask them if they have a potentially dangerous criminal record. Because having the record doesn't disqualify you from work. What disqualifies you from work is if the employer thinks it's likely that you're going to do something to the coworkers, or the employer takes precautions where they just keep an extra eye out if somebody might present the risk. We think taking people's rights to compensation away is always a mistake, and that's why we're unfavorable on this bill. Thank you.
James, with all due respect, the things that you're saying, if I'm an employer, I'm not going to go through all of that. There are tons of people out there that are looking for work. And if I'm going to have to go through all of that extra stuff, I just won't hire those folks. I mean, I don't own a business, but that's just common sense. If I can just say, Delegate Watson, no record or whatever and so forth, and I don't have subject myself to that liability, I'm never going to hire Delegate Wilson, with all his trouble and so forth. It just doesn't, I mean, listen to what you were saying. You said that you have no idea who you're working next to. You have no idea who you're sitting next to in church. You have no idea who's at the grocery store with you. You have no idea who's sitting next to you in a college class. You have no idea about anybody unless we're going to go around putting scarlet letters on people who do stuff wrong. I understand the right to compensation, but that can't be the paramount issue. And that's what it sounds like. Everything is, don't mess with the right to sue, the right to redress. That's first and foremost. It appears that's always the thing. And we've had other issues with as it relates to the 30/60 stuff. I'm drawing a blank now, but it always comes down to the money and the ability to sue for that. As a society, I think, and certainly as a legislature, the policy has to be, if we believe in second chances, if we believe in re-entry, then we've got to remove those types of barriers and those types of scarlet letters. If we're going to say, and you never know. I mean, the fact of the matter is some will some will have recidivism issues. It's a part of it, I think. But if you're going to put that kind of whatever, that kind of weight on the employer, why would they do that? And especially now, if you look at what's going on with the high levels of unemployment, if they need to go hire somebody, we're asking a lot to think that they're going to hire someone who's trying to straighten out their life and go on the straight and narrow, and they've got to absorb all of that risk when you can hire someone who, you don't open yourself up or expose yourself to that kind of liability. So, I mean, is this what you guys are basically saying to us at MAJ, that essentially the right to get redress supersedes everything else?
No, Mr. Chairman, not at all. Our belief is that you can set up a program that encourages people to hire people with criminal records, that provides an insurance coverage for them so that the employer doesn't have to worry about losing their business if they make the wrong decision. But also the coworkers are protected from the potential risk. That's and if this does what the sponsor says it will do, and I do believe that the best way to keep somebody from becoming a recidivist is a job, is the right answer for that. If we create this opportunity, it's going to pay for itself. Look at all the millions of dollars we're paying to incarcerate recidivist offenders. So, I think what you're doing and the points you make and Delegate Wilson make are absolutely paramount in terms of their importance. But we can't just say, forget what happens in the event that somebody gets hurt. Those people, it's not like church. At church, no one says who sits next to me. But with an employer, the employer determines who I work next to and who enters my workplace. So it's different.
Let me ask you this, James. When someone goes to court and they're convicted of a crime and they're sentenced, and let's say they get 5 years or whatever, and they're done, we generally refer that as to them having paid their debt to society. What does that mean, I guess, then, if they really haven't, if an employer is still sort of, hey, he did this and we don't care that he paid his debt. I'm assuming, and I'm not an attorney, so I may be misunderstanding that phrase, but to me, paying your debt to society, I would equate it to paying any other debt. Once that debt has been paid, then, we're good.
And I agree with you. As between
then we shouldn't use that term.
Well, as between the state and the person who paid their debt, they've served their time or paid their fines or done whatever they're supposed to do. But the question is, who speaks for the coworkers? Who speaks for the customer who's ultimately injured as a result of an interaction with one of these people? And they're not here right now because they're not there yet. And we're talking about negligent hiring. We're not talking about strict liability where if you hire somebody, you're automatically responsible. But again, if we care about getting these people back to work and we care about the people that might be injured because there may be an additional risk associated with hiring somebody with a criminal record, let's provide insurance coverage so that when the victims lose their job, lose their house, lose their health insurance because they're injured so badly they can't go back to work because of some horrific interaction with an offender who decided to become a recidivist offender and victimizes them, that they're not bankrupted and homeless because we basically gave the employer a pass. So I'm saying there's equities on both sides, Mr. Chairman, and I salute, you and the members of this committee that are working hard to get inmates, former inmates back to work. And I salute that mission. I just think that what we need to do is to develop a mechanism. And like I said, with insurance, when was the last time you went to a business and they said, for insurance purposes, you can't walk in this room or whatever? That's because the insurance company gets involved and counsels the employer and says, here's the proper criteria for screening these people. Because we know that in the event that the best practices in terms of diagnosing the likelihood of recidivism aren't applied, the insurance company, we're going to have to pay this, right? And insurance companies make money by avoiding having to pay claims. So that's the approach I think that balances the rights of potential victims with the rights of people to go back to work. And like I said, you won't find me saying these people should be stigmatized, that these people should wear a scarlet, letter, or that somehow they're ineligible receivers in our economy. Because if we turn our back on them, they won't turn their back on us. We'll see them back in an institution, and it's going to keep costing us, and we're going to be on this treadmill of recidivism because they aren't plugged back into the system. So that's my solution to the problem that balances the rights of victims and the rights of the ex-offenders.
Did I see your hand, Delegate Charkoudian?
You did, Mr. Chair. I thought you spoke so eloquently to it. I was not sure if I wanted to jump in, but I do have an additional question, Mr. McAllister. So if you're suggesting that insurance is the solution, I am concerned that insurance often plays the role of sort of supporting a cycle of lawsuits, insurance. And so it kind of keeps an economy of lawsuits going. But putting that aside for a second, so you're essentially saying, who would pay for that? You're essentially are saying that it would have to cost more for the employer to hire an ex-offender? Is that what you're saying, returning citizen?
Well, I'm saying at some point, the General Assembly could come up with a premium support that would support employers hiring these people. And, if the premiums are relatively inexpensive, then that hiring these ex-offenders doesn't present a major risk of recidivism.
So who
if
would
the premium is high, then that's even more reason to have coverage.
So you're saying that the employer would then have to pay more to hire somebody that we already have a stigma. We already have challenges getting with folks who have a couple strikes against them trying to get jobs. And now on top of it, we're going to say to the employer, not only are we not going to cover you and protect you, but also you're going to have to pay more for this insurance in order to hire this qualified person, but someone who has made a mistake in their life and has paid their debt to society. Is that
no? Let me just.
Who's paying for it?
The answer is I think that it should be funded by the state of Maryland. The state of Maryland has an interest in getting people back to work. The state of Maryland has an interest in protecting coworkers. The state of Maryland has an interest in cutting down recidivism. This should be a program where the state goes to employers and says, if you hire an ex-offender and something happens, you will have insurance to protect you as long as you do what the insurance company tells you to do in terms of taking best practices precautions.
And what would those best practices precautions be?
Well, I mean, if you look at, all sorts of insurance, whenever insurance is underwritten, the carrier assigns an underwriter who evaluates the risk.
It seems that just sets up to pull people out, and I'll just keep using the scarlet letter term, like scarlet letter them even further to say, like, if you're going to hire this person, keep them 6 feet away from this person and 25 feet away from there and not these folks. And I have one other question for you, which is, are you able to sue right now? Are you able to sue an employer if someone turns out to sort of have a anger management issue and they didn't sufficiently find out if that they hired the person without sufficiently finding out, so someone who doesn't have a criminal background but gets angry easily, or someone who maybe is a member of a domestic white supremacy terrorism organization, or, are you able to sue an employer for not finding all of these things out beforehand and then having an incident occur at work? Or is it just specific to the criminal background that you want to protect the ability to sue the employer?
No, I mean, employers owe an obligation to coworkers and to customers to take reasonable precautions to protect customers and coworkers. So that's called negligence. Well, what's reasonable under the circumstance based on what the employer knew or should have known? So if you arrive and you're, let's say, some combustible individual who has a hair trigger in terms of anger, but you've got no criminal record, no history, and they see nothing, and then one day you explode and go crazy, that's not a negligent hiring case because the employer had no reason. A reasonable employer who takes, care to know what's going on wouldn't have known that.
So I guess the concern that I have is to somehow suggest that we are that we're taking a criminal background as something separate from all of the various things that might make it dangerous for me to be working next to somebody, and isolating that and protecting your ability to sue based on that, when there's any number of other things that of course an employer could know or not know that could potentially put me in danger in that workplace, possibly even more so than somebody's criminal background. But that's more of a statement, and isn't that so, than a comment. Thank you for your time. Thank you, Mr. Chair.
Sure.
Mr. Chair.
Delegate Watson, then Delegate Demett.
Thank you, Mr. Chair. The gentleman that was just testifying disappeared from my screen, so I can't see his name or his face. Is he still on?
Yeah. It's Jim McAllister.
Yes.
I should be
Yes.
here.
Could you just, would you just briefly tell me again what your role is or your position is professionally?
I'm a trial lawyer. I've spent 35 years handling personal injury cases, workers' compensation cases. The first 5 or 6 years, I did defense work. I've filed negligent hiring and negligent supervision.
Okay,
cases.
thank you. Thank you. I just I missed that in the beginning. So is it your position that the employer's liability, which is provided as part of the state mandated workers' compensation coverage in a workers' compensation policy, would not provide coverage for an employer who hired an ex-offender who had served his time?
It would not, as to the employer, if it's a contractor of the employer or somebody who is there working next to somebody, there's liability for that. But the point you make is a good one, which is if you are injured on the job as a result of your employer's negligence, in Maryland, your exclusive remedy is workers' compensation. So let me amend
and
that.
just wait, one second. So if you're injured on the job, your injuries are covered by, your medical payments are covered by workers' compensation, but also there is an employer's liability portion of workers' compensation. When the employer is negligent, that is a coverage that can be used, correct?
No, you can't sue your employer at all. So if I get hurt, because I'm working next to an ex-offender who's been hired by my employer, and I get hurt by that person, and we both work for the same employer, my exclusive remedy is workers' compensation.
But the employer's liability is a portion of the workers' compensation coverage on the workers' compensation policy.
On the workers' compensation policy, we don't call it liability, we call it economic loss. You recover.
Wait. I just want you to know that I'm an insurance agent.
Okay.
Sell workers' compensation policies every day for the last 30 plus years.
Mm-hmm.
There is coverage for employers' liability on every workers' compensation policy, and that's what they call it.
Well, what I'm familiar with is two things. Number one is workers' compensation benefits, and the other is, in Maryland, a coworker can sue a coworker. So if I'm riding in a vehicle with my coworker, I can sue them, and the employer's liability coverage covers them. It's called a co-employee suit. So that's perhaps what you're talking about, but maybe we're talking past each other. I can't tell.
There is an employer's liability coverage on the workers' compensation policy that covers incidents of employer negligence. Would you agree?
No.
Okay.
I mean, not in my experience. And
then we're going to agree to disagree.
Okay. There's a statute in Maryland that says that workers' compensation is your exclusive remedy, and that's all you get when you're injured by a coworker. Not so with an independent contractor. Not so if the person causing you injury is a coworker.
I'm sorry, but I can't let it go. Workers' compensation, you're saying there's a statute in Maryland that says workers' compensation is the only thing that you're eligible for. Is that what you just said?
Yes.
Okay. So what do you mean by workers' compensation?
Workers' compensation pays 2/3 of your average weekly wage, called temporary total disability. It pays permanent partial disability in the event that you have lingering complaints after the accident.
Okay.
And it pays causally related medical bills.
Okay. So that is one portion of a workers' compensation policy. There is another portion called employer's liability. I'm just going to leave it at that. But when you say you're only entitled to workers' compensation, you're talking about compensation for disability and injuries. And I am talking about something different that's on the policy called employer's liability. So I guess what I think we're going to have to agree to disagree here.
That's fine. You've obviously looked at something different than I have.
I look at workers' compensation policies every day.
I don't. I look at the benefits my clients are entitled to under the law, and that's what I know.
Thank you, Mr. Chair.
Delegate DeMay.
Thank you, Mr. Chair. Mr. McAllister, I know enough about workers' comp to be dangerous too, but regardless, the type of case, if someone was going to sue an employer for negligent hiring, would that be covered by their business liability insurance? Unless it was over and above, policy limits or whatever, but technically they would have liability insurance and this type of action would be covered by their liability insurance.
That would, yes.
Okay.
And that's currently the case.
Right. And do insurance companies, to your knowledge, currently advise their clients to take certain precautions regarding hiring?
I believe they do. Again, I work on the opposite side of the tennis net, so.
Right.
But I do, when I did defense work, at least back in the 80s, they did.
Okay. I've often struggled with this bill because I certainly, in my former life on the Judiciary Committee, spent a lot of time talking about how do we get people to re-enter society and to do it in a positive fashion. So do you have a sense of how many of these cases you see on an annual basis?
Well, I think the reason it's the ones you don't see, and it's the ones you don't see because people come into somebody's company and they don't get hired. And so therefore you don't see the cases. I think, and the fact that the liability policy covers it is a disincentive for the employer to hire that person because they're thinking, wow, if I hire this person and they cause some catastrophic injury to somebody, my insurance rates are going to go up in the future. So that's why I'm saying if we can protect them from that concern through a substitute insurance coverage, I think it speaks to making these people, if you're an employer and you're hiring somebody that has no criminal record, you have no idea what they're going to do. And whereas if you're hiring an ex-offender and there's insurance coverage, that makes that person a lot more attractive to hire because you now know, A, it doesn't go on your insurance if something bad happens. And number two, you're relieved of at least the unknown of hiring somebody that doesn't have a record and trying to piece together what you may or may not know about their risk presentation. So.
Okay. Thank you, Mr. Chairman.
All right, Delegate Impalaria, Delegate Fennell, and then Delegate Mouts.
Thank you. Mr. McAllister, you have picked a tough crowd and a tough subject, didn't you? Well, we appreciate what you do. And I see both sides of this argument, and there is two sides to this argument. If I'm Uber, I want to be careful who I'm hiring to be an Uber driver because they're going to be isolated and alone with this customer. And it's not just the employee, it's the customer that we're talking about also. And that is a concern of many companies. But what I find most interesting about this piece of legislation is that I could go through a whole bunch of testing and approvals by the state of Maryland, all kinds of schools, and then go to apply for that license. And the state of Maryland will say, you have this criminal charge. I don't care if you went to 4 years of school. You aren't allowed to do that. So I think before we start picking on the businesses, we need to re-look at the state's policy of who they prevent from having licensure to do certain types of jobs. And so why does the state feel it's important to protect themselves from giving this license to somebody, but they're telling, a company like Uber, you should just hire these people no matter what. And we know there's been problems with people attacked by Uber drivers. So what's your thought on that?
Well, my thought is that you know, I think there's a concern, and all I'm speaking to is a concern. I'm not speaking to a discrimination or a bigotry or, a red flag that marks these people as ineligible receivers. What I'm speaking to is a way of, addressing a risk while still safeguarding the people, that these folks work with and the people they interact with. And I wish the state of Maryland would do the same thing with other things, because if there's a concern that somehow a conviction for something renders you ineligible to do something, that basically is based on the assumption that people never change. And, if there's anybody in the room or on this chat that hasn't changed, at one point in your life, God bless. But I think you speak to an important issue beyond this bill.
Yeah, and it's a double-edged sword, because yes, I do want to give this person a chance, but when I do, who's going to protect me because something went wrong? And that's what you're saying. Who's going to protect the person who takes that risk? And that is your whole point. And my secondary point is, before we start implementing this on businesses, let's try this out with the state of Maryland on who they give licensures to. And if they're saying that you had a charge 25 years ago and that charge precludes you from getting this license that you just went to school for 25 years later, shame on the state of Maryland. And we should look at ourselves first before we go after the businesses. And I hope that Delegate Wilson may take that bill up next year to look who we're denying licenses to in the state of Maryland to do certain business practices. Thank you.
Delegate Mounts.
Thanks, Chairman. I wasn't going to get into this. I'll make it very quick. But Mr. McCosker, you were recommending an insurance policy for hiring felons. Is that what you were suggesting?
Right. And in your situation with your restaurant, if someone comes in and says, I have a criminal record, or
don't talk about me personally. You can talk about all restaurants. Just
well, it's not about all restaurants,
ethical violation.
We have, my favorite ones come to mind first. So you've got somebody who walks into a restaurant and says, I need a job. And somebody looks that guy up on judicial case search and finds out he's got a criminal record. Well, the first thing in your mind is, what am I signing on for here? And what do I do? And, because if I hire this guy and he winds up doing something horrible and I get sued, my insurance rates are going to go up. Plus, people that run restaurants like yours care about their employees and don't want to expose them to risk. So what do we do? So my suggestion is, let's come up with a way of saying to you or to the restaurant owner, look, if you hire this guy and something happens, you're covered.
So, yeah, but your answer was yes, that was an insurance just for hiring felons. So have you sued a business before?
No.
You have not sued a business. So usually
I thought I said I've run a business. No, I've sued plenty of businesses.
Yeah, usually you sue a business and there's an insurance policy, and that insurance policy makes a settlement offer whenever there's a suit filed. Isn't that right?
I wish. Otherwise, I never would have seen the inside of a courtroom. So, they make an offer sometimes they deny it. And
right.
You wind up trying the case.
Right. So I could see a lot of businesses seeing this sort of as a slush fund for bringing suits against businesses. And I guess, as far as liability and running a business, I guess I'd ask you if you'd ever hired a felon or had a felon work for you.
When I worked in a restaurant back in the 70s, when I was working my way through college, I did hire somebody who was had a criminal record.
Okay. Well, and
it worked out fine.
Okay. Well, I just wanted to get your perspective and your background, because you're testifying to this, and it's pretty interesting from a business perspective, and then to get your perspective. But I would see this as a huge problem for businesses that would encumber a new insurance policy just for all the other liabilities they have to deal with, and then add a new one that would open up an opportunity for someone to take them into court. I don't want to take up this much time, Chairman. Thank you.
Did I miss you, Delegate Fennell?
Yes, thank you.
I'm sorry.
That's okay.
My question is, so are you saying that an ex-felon should not be hired unless the state of Maryland insure them? Or are you saying that an ex-felon should not be hired at all?
No, what I'm saying is, right now, there's no prohibition on hiring ex-felons. And what this bill speaks to is a bias by employers about hiring ex-felons. So there's no current prohibition on it. And the way the bill speaks to that bias is to say, you won't be accountable if you hire the ex-felon. If the ex-felon winds up hurting somebody, you'll be immune. The victims will have no claim against you. My suggestion is, that we instead provide insurance, not at the cost of the employer, but at the cost of the state of Maryland, that covers employers who give ex-felons a chance and exercise due care. That way, their insurance doesn't cover it. They don't have to pay a premium increase because they're hiring. You call up your insurance company and say, I want to hire a bunch of ex-felons. You know what they're going to say? Your premiums will go up. Okay. This protects the employers who do the right thing. Does that make sense? Did that answer your question?
Actually, no, it doesn't. It doesn't answer my question. Thank you.
Okay.
Am I forgetting anybody? Going once? All right, thank you very much. Mr. McAllister, thank you.
Thank you, Mr. Chairman and members of the committee.
Let me see, yeah, that concludes the witness list for House Bill 420. I'd now like to go to our final bill of the day, House Bill 642, Delegate Polakovich Card, who has been waiting patiently. Welcome, Delegate.
Afternoon. Very interesting conversation, so no problem at all. Well, for the record, I'm Delegate Julie Polakovich Carr, here to present House Bill 642, which seeks to increase the accuracy of consumer data. The current problems in the consumer reporting industry are best demonstrated by the story of Devon Jackson. Devon was looking for an affordable apartment for himself and his young daughter. He had never been evicted and had no criminal convictions or arrests, so he thought his biggest hurdle in finding an apartment would be finding something within his meager budget. When Devon found a decent apartment in his price range, he applied and was told by the landlord that they needed to run a consumer report on him. A consumer report is like a credit report, but contains additional information such as arrests and criminal convictions, prior evictions and rental history, and employment information. The report on Devon was prepared by an external screening company that uses computer algorithms to run automated background checks. Within seconds, the algorithm generates a report that recommends approval or rejection of the applicant. Most of these reports are not reviewed by a human before they are provided to the landlord. In Devon's case, the report came back with an elevated risk score, and the landlord rejected his application. When Devon asked why he'd been rejected, the landlord directed him to the consumer reporting company. He obtained a copy of his consumer report, which showed criminal records for an Eric Jackson and a James Jackson. Even though these people had different first names than him, their information was erroneously included on his report. Devon filed a complaint with the Consumer Reporting Agency, which made the corrections within the 30-day timeframe allowed under federal law. But by then, the landlord had already rented the apartment to another person. 90% of all landlords use an automated tenant screening report to make rental decisions. And there are approximately 2,000 consumer data companies in the US and no centralized way to correct all of your consumer reports in one shot. Devon subsequently struggled to find another apartment. He and his 9-year-old daughter then spent nearly a year living in a motel room. Devon Jackson is a real person who had his life upended
the department is mandated
because of inaccurate consumer data. Unfortunately, every day, Marylanders are rejected for a job, an apartment, a loan, or insurance, or forced into higher priced credit because of inaccurate or outdated consumer information. Errors in consumer reports are shockingly common. The Federal Trade Commission reports that 1 in 4 consumers have a potentially material error on their consumer report that makes them look riskier than they actually are. Here in Maryland, we have one of the highest per capita rates of consumer complaints in the nation, according to the Consumer Financial Protection Bureau. Over the past 2 years, more than 10,400 Marylanders have filed complaints to the federal government about their consumer reports. And that number is growing at an alarming rate. From 2019 to 2020, the number of complaints filed by Marylanders increased by 60%. A major cause of these complaints is the inclusion of information for different people on a consumer's report. This has been well documented in settlements reached by the federal government and in a settlement by 31 attorneys general against the 3 largest consumer reporting agencies. The solution is to require consumer reporting companies to live up to the accuracy standards set in existing federal and state laws. Companies are already required to achieve, quote, maximum possible accuracy, end quote. The legislation before you would direct the Commissioner of Financial Regulation in the Department of Labor to promulgate additional regulations for how companies can meet their existing requirements regarding accuracy. Now, the opposition is going to tell you that this legislation would be the first of its kind in the nation, but Maryland is already a national leader in regards to consumer protections because of the work of this committee. 3 years ago, this committee passed legislation to establish a bonding requirement for consumer reporting agencies, which was the first of its kind in the nation. And before that, Maryland was on the forefront of protecting youth and seniors in regards to consumer security freezes because of the work of this committee. I urge you to continue on your path of strong consumer protections by giving HB 642 a favorable report. Thank you for your time and consideration.
Thank you, Delegate. Are there any questions for Ms. Polokovich-Carr? Delegate Wilson.
Thank you, Mr. Chair, and thank you, Delegate, for bringing the bill. My questions really don't have anything to do with the policy. I believe the policy is extraordinarily sound. I like what you're trying to do, having more accountability than just, well, we think you did it, so you prove you didn't, which is kind of what happens. My concern really boils down to the enforcement mechanism and how do we apply this to businesses outside the state? Because I would be I think it's a great idea. I'm just not sure it's doable.
Yeah, thank you for the question. So my understanding is under the legislation that this committee passed a few years ago, all consumer reporting agencies that are doing business in the state of Maryland are now required to register with the Department of Labor. And I believe there's 57 companies, or at least that's the most recent number that I heard, that have registered with the state. So theoretically, the state knows the universe, although it's a much bigger number nationally. I mentioned it could be as many as 2,000 companies. It's a much smaller universe here in Maryland. So hopefully that makes enforcement actually, doable, as you say.
But what would the enforcement mechanism be? And again, like I said, if we narrowed it down to the 57 that we feel are going to be acting in Maryland, what would the enforcement mechanism be?
Right. So the legislation doesn't specify anything in that regard. And I'll say that actually was a consideration as I was pulling the bill together. Part of the reason I did not include anything specifically was in those deliberations a few years ago, the bill that did pass your committee originally did include enforcement mechanisms and fines, and those have been stripped out. And so I chose not to include them in this legislation, given that the committee had just weighed in on that just a couple of years ago.
And I also appreciate that because I think sometimes our Consumer Protection Act can be extraordinarily draconic, but I would be interested in seeing how we can make this happen if it's possible, because I think it's a good bill. Just wanted to make sure that when we make it law, that there's some mechanism to make sure that people are, following the law. Thank you.
Mm-hmm. And I'll just say thank you for raising that. And it's certainly, if that's the direction that the committee wants to go, I would be supportive of that.
Thank you.
Anyone else? Thank you, Delegate. Marceline White.
Good afternoon, Chair, members of the committee. For the record, Marceline White, and I'm with the Maryland Consumer Rights Coalition, which works on economic rights and financial inclusion. We're here in strong support of House Bill 642, and I want to thank the delegate for bringing this legislation. As this committee knows, and as was referenced, this committee has worked over a number of years on issues of credit reporting and errors in credit reporting bureau, the credit reporting bureaus have made, and the challenges consumers face when there are errors in their credit reports. Again, during a time of a pandemic, this is so critical because this can be the difference between a new job, a new apartment, or access to credit or loans. If there's a mistake in the credit report, consumers can be denied. And we're obviously in a very fragile state with the pandemic and the economic recession. So we need to make sure that this is right. There are a series of common mistakes that are made that we've talked about in this committee before that you all have deliberated on, including reporting information about someone with a similar name, reporting information that should have been sealed or expunged, or reporting information in a misleading manner. This is a common sense solution to a problem that continues to plague Marylanders. It creates the opportunity for the Commissioner of Financial Regulations Office to promulgate regulations that make sense, that are within their capacity to investigate and enforce. I do want to mention that just today, a report came out looking at the fact that consumer complaints regarding credit reporting rose by 60%. And the report delved into this a little bit more and said that personal information being incorrect had increased in the past year by 160%. The fact that investigations took more than 30 days had increased by 715% in terms of complaints. And the fact that the consumer wasn't notified about the results, the complaint rose by 558%. So this is a great solution to a problem we know Marylanders have, and we ask for your support for House Bill 642.
Any questions of Ms. White? Seeing none. Ariel Nelson.
Thank you, Chair Davis and members of the committee. My name is Ariel Nelson, and I'm an attorney at the National Consumer Law Center. My work focuses on how inaccurate background screening reports cost consumers housing and jobs. I'm testifying in favor of HB 642. To nail down an apartment or job, you almost always have to pass a background check. About 94% of employers and 90% of landlords run criminal background checks, and about 85% of landlords review eviction records. Many landlords and employers purchase reports from specialized screening companies. These companies often match applicants with records based on overly loose criteria like partial names or incomplete dates of birth. And many deliver reports without verifying the initial search results, meaning that no human even glanced at them to make sure there weren't any obvious errors. Practices like these, along with the use of outdated or incomplete data, lead to mistakes like the inclusion of somebody else's records or expunged records. These mistakes have serious consequences. Take what happened to Glenn Patrick Thompson Sr. and Jr. They were left homeless after a screening company told two landlords that they had an eviction record. The record actually belonged to a Patricia Ann Thompson, who they did not know. Government enforcement actions, private lawsuits, and investigative reporting all indicate that errors are common, but individual screening companies say they have low error rates. These statistics can be misleading and don't tell the full story. For instance, they don't take into account the full universe of errors. Companies often assess the accuracy of their products using raw numbers of complaints, but not all consumers dispute errors, even if they actually know they were turned down for a job because of one. Further, even if you accept the error rates offered by individual companies, those percentages obscure the simple fact that inaccurate reports continue to harm, at the very least, hundreds of thousands of consumers. That's too many. Nobody should be turned down for an apartment or job because they were tagged with someone else's record. As we face the economic fallout of the pandemic, it's more crucial than ever that companies get things right. That's what HB 642 will help do, including by requiring regulations establishing stricter matching standards. When people's financial lives and reputations are at stake, that's not asking too much. Screening companies already have the ability, as one court emphasized, to obtain enough information to figure out whether a record belongs to a consumer. And as another court explained, one company could have avoided wrongly identifying one man as a sex offender if he had simply compared his birth date to the birth date in the data it had used, or had reviewed the actual government records. Also, the big three credit bureaus already use stricter criteria, either a social security number or a date of birth, similar to what the regulations here would require, to match records to consumers. Screening companies, gatekeepers to jobs and housing, should be held to that standard. I thank you for considering this important legislation and ask for a favorable vote.
Questions for Ms. Nelson? Seeing none. Thank you very much. Is Chris DePietro with us?
Yes, I am, Mr. Chair.
Hey, Chris.
Hey. So this is members, Mr. Chair, members of the committee, this is Chris DePietro. I'm here on behalf of the Consumer Data Industry Association, respectfully in opposition to this bill. CDIA is the trade group that represents consumer reporting agencies, including the nationwide credit bureaus, as well as regional and specialized credit bureaus and background check companies. I think I first want to say is that we did meet with Delegate Polakovich-Carr last week to talk about our concerns. You'll see all our concerns detailed in a written testimony that we provided to the committee. I think our goals are the same. We want accuracy in the reports that we provide to individuals when they are making decisions about leases or anything else. There was a little bit of a conversation on the last bill about erroneous or different requirements for state licensures for different state licensed individuals. So this is all impacted by that. I think our concern is that there are many unintended consequences to the approach that this bill takes. And I think they're probably in a different bill, and we offered this to the delegate last week, in a different bill and a different approach. I think we could be on board with trying to require, for example, requiring the courts in Maryland to put very specific Social Security number information in these public records so we can do an accurate match and improve the accuracy rates. One thing I just really would be remiss if I didn't point out is that one of the unintended consequences of this bill is if you look on page 4 on number 2, lines 5 through 7, it says that we have to get the other identifying characteristics such as gender, race, ethnicity, or physical description of the consumer. I don't think, and I think the delegate agrees with us here, that is not something that you want to do, because then that data, that information could be used against an individual based on those exact characteristics. That is not what we want in a reporting system. So I'm going to, I know we talked, the delegate talked about all the work that this committee did a couple of years ago. There was a 2-year process where the Commissioner of Financial Regulation adopted and promulgated rules. Our industry is, we have to register with the Commissioner's office. We have the regulations that just went into effect, which we think are very robust, went into effect last fall. And we also have to be bonded. So there is a lot of latitude that the Commissioner does have to regulate this industry, to ensure accuracy. We want to be a partner in that because the quality of our reports is our commodity. So I do have with me today Eric Ellman, who will be testifying after me and probably could give a little bit more detailed analysis of why we oppose this bill. Thank you.
Questions for Chris? Rick, Delegate Impalaria?
The interesting thing on listening to all this is that, and Chris, you probably could back it up, probably goes both ways. There's probably times that someone has a horrible record, and because of that mistake, some poor landlord, some poor business ends up hiring that person thinking it's someone else. And you know, it's interesting, I can see that Delegate that's presented the bill and Delegate Sharkouni and myself have absolutely no problem with this ever happening to us, with our names all being 10 letters and more. So no one's mistaking us, and we get now. Sometimes I wish I got a break that they would think I was somebody else, but that doesn't happen. So I can imagine this is something that cuts both ways. It's just not the negative side. There's also on the other side of the landlord or who nailed by taking on someone that the information's wrong.
Yeah, I think the point that you were making on the last bill about like all the license classes, I mean, DLLR, I mean, Department of Labor, they license all kinds of individuals. And think of how many bills the General Assembly has passed probably in the last 10 years that require background checks of individuals. And why do you do that? As a government, you want to ensure the safety of our citizens, and you're not going to give a license to a daycare center operator if they had some conviction. Now, what if a bill like this was in place and we weren't able to do the match according to the parameters of this bill? Therefore, it would be left off. And then that you're putting that population, the people that the parents that are leaving their kids at that daycare, you're leaving them at risk then, because we would be forced, not forced, but the state would ultimately give that license, and you're going to be putting somebody else at risk. So it does, yes, it does cut both ways.
Thank you. Delegate Charkoudian.
Thank you, Mr. Chair. I have a couple questions. The first is, do you, I'm just trying to figure out when there's a mistake where the implications are. Do you, how do you get paid?
Me personally?
Well, you personally, sure, but I mean, how do the companies get paid?
No, the companies actually, they get paid obviously by selling reports. So
do they get paid the same amount if they have an error or if they don't?
I would leave the specific answer to that question to Mr. Ellman, who's going to precede me because he represents them directly.
I suspect the answer is yes, but if he wants to clarify that for me. And I guess the reason I asked that question is that really the implications of where the harm is if there's an error is really stark in this case. And so the implications of an error leading to someone not getting a job, not getting a home, where you're paid in the same regardless. You know, there's a question about what the incentive is. I mean, I'm sure that overall you want to get it right, but on an individual case by case basis, it's not clear that there's an incentive to really go out of your way to go with something that's going to cost you more if there's not an implication, any kind of a negative incentive on you if you get it wrong. And I say that, you know, there's a cost. It sounds like even Delegate Impleria's point about whichever way you get it wrong, you know, there's not a cost to you. There's a cost to everybody who's counting on using that data.
Well, I think can I answer? Would you like, or do you have more?
Yeah, no, I have another question, but you can go ahead and answer that.
Yeah, I think my response to that question, I think it's a very valid question that you asked right there. So I think the incentive for us to get it right is like any other business having to provide a quality product. If you do not provide a quality product, and in our case, if we provide incorrect reports and consistently provide incorrect reports to a landlord or to whoever else depends on that information to make decisions, and they realize that they're getting bad data from us, then yes, that is an issue. Then that company is not going to do well. So it's important. It's very important for us to be accurate. So is there a cost difference whether you pay for a report that has an error in it and one that doesn't? And I want to be 100% clear. There are errors that happens. And there's no perfect system. As long as humans are involved, there's never going to be a perfect system.
So let's talk about how to make it more perfect, though.
Right.
I guess the other concern that I have is that it just from where the other imperfections are in the system, it seems that there's imperfect information, right? So if a landlord pays you for a report, gets a report back, doesn't give somebody a home, even though they would otherwise have met the requirements if the information had been accurate, and then it takes that person 30 days to fix that, that landlord may now have given the home to somebody else, may never find out that they paid for an inaccurate report, right? So there's an element of where you want your reputation overall, your reputation depends on generally having accuracy. It's not clear that there's always perfect information about the inaccuracies, you know, sort of all the way around in a way that it would affect business. And I think there is definitely sort of a lack of symmetry in the implications for your business and somebody's life if there's an inaccuracy. And I think those are the places where it's appropriate for government to step in with regulations. So,
and I understand that point, and I agree with you. And I think there probably are lost opportunities for individuals that are victim to an incorrect report. But I'm saying my thought is where government could step in is helping us to make sure that the information that we are receiving, and in this case, we're talking about public records from government, from the courts of Maryland, to do things to those reports to ensure a better accuracy rate. Well, we'd love to partner with the delegate.
Yeah, I mean, there's reasons that we can't stick social security numbers into publicly available data. But let's talk about the gender and race piece for a second, because it seems to me your concern about putting gender and race and other physical identification pieces into a report are right, that you wouldn't want those to be used by a landlord to discriminate against somebody. But is it possible that you could use those identifiers to make sure that you've got the right person and you're reporting accurately on the right person, but not have those identifiers be part of the report itself?
No, I agree. Yes, and there probably is some way to do that in that particular instance, and that is we discussed this with Delegate Polakovich-Carr when we met with her last week, that was a concern. The language as it stands, and we have to talk about the bill as it stands, doesn't account for that. So there is a real risk and a real unintended consequence. And even if you do create a parameter, some parameter of how that information is used, it's going to be stored somewhere. And if it's stored somewhere, it's going to be accessed somewhere. And ultimately, in the wrong hands, that could be used to further discriminate against the people.
I'm sorry, the person you were trying to reach has a voicemail box that has not been set up yet. Please try your call later. Goodbye.
Sorry, thank you.
Walker, mute yourself.
Is that into your questions, Delegate Charkoudian?
I was hoping to listen in on Delegate Walker's conversation, but yes, since you don't get to do that, I'm gonna go ahead and say that I'm done now. Thank you, Mr. Chair.
Delegate Queen.
Thank you, Mr. Chair. Thank you for your, the testimony. So I'm just going to make it real simple, and you can get back to me on this. So you mentioned at the end, Chris, that you want to be a partner in this and to get this right. And so what I'd like to get from you are some amendments that are going to get this right, that does not look at people's personal information, does not put the state in a position that we can't give you that information. But I want meaningful amendments that can help us get this right. That's all. Thank you.
Thank you. We'll be happy to work with the delegate on this. I'm not sure if we can amend this bill the way it's drafted at this point, but I think there is a way, if we can collaborate, there's a way we can achieve both.
Delegate DeMay.
Thank you, Mr. Chairman. Mr. DePietro, I'm trying to determine, because again, it's a somewhat new area for me. Who are these regulations going to apply to? I'm assuming that we're not talking about the 3 national Equifax and whatever it is.
Union Experian. Yeah.
So is it just Maryland company? Is it your understanding that it's just Maryland companies that these regulations would apply to?
I think, well, first of all, the regulations that are in effect now that were adopted and made final in the fall apply to all the credit reporting agencies, the 3 large, in addition to the background check companies and the others that are members of the trade association that I represent. So I do think it would apply to all of them, but I'm going to defer to a complete answer on that question to Mr. Ellman, because I think he would have a better answer for you.
Okay, well, I think all of my questions are sort of trying to follow the jurisdiction, and if he's better to answer those, I'll wait. Thank you, Mr. Chairman.
Anyone else from Mr. DePietro? If not, Mr. DePietro, before we go to Mr. Ellman, I actually inadvertently skipped over Mr. Eric Dunn. So I'd like to go to Mr. Dunn, and then we'll come back to Mr. Ellman.
Sure, thank you.
Thank you, Mr. Chairman, and thank you, members of the committee, for having me. My name is Eric Dunn. I'm with the National Housing Law Project, and I've been working on rental screening and tenant admissions issues for about the last 15 years, and I've observed a lot of the problems with accuracy. I was actually the lawyer who represented Glenn Patrick Thompson Jr. and Sr., who Ms. Nelson had mentioned earlier, and so I'd like to talk about some of the details of eviction records for just a minute. As Ms. Nelson mentioned, what happened in that case was these 2 men, Glenn Patrick Thompson Jr. and Sr., were living in a truck because they couldn't find a landlord who had rented them, because every time they applied for housing, an eviction record that belonged to somebody named Patricia Thompson, who they didn't know, had never met, but had an eviction record in the same county as them, would come up and be matched to them as if it was their record. And why did that happen? Well, it happened because what's called the matching logic, which is the software that chooses which records belong to a particular rental applicant, didn't distinguish between a first name and a middle name. And it didn't distinguish between the name Patricia and the name Patrick. And it also wouldn't have distinguished between another name like Pat or Patrice or any other name sort of in that family of names. It wouldn't distinguish between a name that's commonly used for a male versus a female name, Patricia Patrick. The computer just does what it's programmed to do, so it would match them together and they would be automatically denied housing, because the way most rental screening works nowadays is that the landlord just gets a yes, they qualify, no, they don't, and the landlord may not even know why the computer turned them down. Now, could they dispute that? Yes, but in order to do so, they'd have to request their screening report, which requires, first of all, they have to understand that they have a right to get the report. They have to understand where to get it from. They have to go through that process. They were living in a truck, and a lot of screening companies won't send you your report if you don't have a stable address to receive it from. So that's a barrier. Once you get the report, you have to actually be able to read through it and understand the contents in order to be able to make a dispute. That's an impediment for a lot of folks, especially when we look at criminal records. Criminal records are usually put into different categories. And so there's more than 10 million unique types of criminal offense descriptions in the country. So one state might call something aggravated assault, another state calls it assault second degree, and another state calls it felonious assault, and it's all the same crime. And so these computer systems have to filter these crimes into certain categories, and then it will deny an applicant, based on a category of crimes, and you have no idea how your crime was filtered and what category it was put in. So if you were denied for a criminal record for assault, it should have been categorized as something less serious than what it was put into. You'll never see that in the report. And I want to respond to the comment that Mr. DiPietro made about how this bill would lead to there being social security numbers and dates of birth and personal identifiers like that in public records. That's absolutely not true. Courts don't prepare their records for the use of consumer reporting agencies, despite what the industry may want you to believe. Eviction courts prepare records to keep track of their hearings and their cases and the parties and so forth. Landlords don't need to put in the date of birth and the social security number of somebody who's being sued for eviction. They just put in the tenant's name and the address. So how do you make sure that you have the right person? You have to compare the address of the property to the address of the consumer applying for the new housing, which you can find from their credit report or usually a written application. But that requires work, and that requires people to compare these things. And computers can't necessarily automatically do that type of thing. And so it increases costs, and screening companies don't want to do that. And so that's why they object to these things. But it doesn't require courts to start putting this information into public records that screening companies can mine it and use it against people. So I think that's a complete misstatement of what this bill would do. But I see that I'm over time, so thank you.
Any questions? Seeing none, thank you very much. Eric Elman.
Good afternoon, Mr. Chairman, members of the committee. Eric Elman with the Consumer Data Industry Association, CDIA. We are the trade association representing the consumer reporting community, which includes the nationwide credit bureaus, as well as many other of the nation's leading criminal background check companies. This bill should get an unfavorable report for at least 6 principal reasons. First, public records, when used by private companies like consumer reporting agencies, are accurate and reliable, and respectfully, we disagree with the proponents and the anecdotal evidence that they provided. Accuracy is the lifeblood of the consumer reporting system, the consumer reporting industry, and consumer reporting agencies maintain their files with a high degree of accuracy. In fact, the FTC said that there is, quote, a market incentive to maintain and improve the accuracy and completeness of consumer reports, end quote. Several leading federal cases, which I've noted in my written testimony, have discussed the high degree of accuracy of public records, 99.8%, 99.6%, 99.7%. When consumer reports are empirically tested and looked at in a broad spectrum across a variety of federal courts, appellate and district courts, the accuracy comes out extraordinarily high. Number 2, second reason for an unfavorable report. Standards already exist governing the accuracy of consumer reports, including substantial new rules on which the ink is barely dry from the commissioner in the state of Maryland. Maryland has amongst the most strict rules governing the consumer reporting industry. In fact, the rules that they just imposed are directly addressed at the accuracy of consumer reports. Reason number 3, the bill would make communities less safe by making it harder to conduct a criminal background check. Matching on all 9 digits of a social, matching on a full DOB means no matching at all. That means that it's going to be difficult, perhaps impossible, for a daycare center to get a positive match on somebody who's applying to, that happens to be a pedophile, a landlord who's wants to rent to somebody, but who turns out to be an arsonist. Reason number, and the FTC in a report said on full matching, concluded that full matching is harmful for consumers because, again, a full match means no match. Reason number 4, the bill could violate and promote discrimination. It takes us back to a day when credit reports included personal characteristics like your race, your religion, your creed, your color. Nobody wants to return us back to that time. That's why we have fair lending laws to take discrimination out of the system. 5th, the bill is preempted by federal law. 6th, we want to work with the state to promote accuracy in records at the source, at the court records, in the clerk's offices, in the central repositories. I'm happy to answer any questions that the committee has.
Any questions?
I do, Mr. Chairman.
Madam Vice.
Mr. Ellman, can you, one of the last things you said is sort of goes to the question that I was after, which is, tell me how federal law preempts this.
Yeah, a couple of reasons, Madam Vice Chair. The FCRA, the Federal Fair Credit Reporting Act, which governs the accuracy of consumer reports and has been in place for a half a century, on which the state statute is based, regulates the accuracy of consumer reports, regulates the content of consumer reports. And any state regulation at this point that impacts the accuracy of the reports or the content of the reports is going to be preempted by federal law.
Okay. And so are Maryland regulations currently in line with federal law?
The way we read them, yes. Additional regulations would not be.
Okay, so the regulations that are being proposed to address what's in this bill would be beyond the federal law.
That's correct.
Okay. And perhaps you can also answer a question. And again, it's the federal law covers sort of state credit reporting agencies as well as the big 3, you know, and I imagine some of these credit agencies work across some state lines in some regional manner. Is there any requirement in law now that says that the consumer should be provided a copy of their report? I did hear what Mr. Dunn had to say about, you know, these reports can look complicated and be difficult for an individual to understand, but is there anything in law that would suggest that if I'm denied housing, that the landlord has to give me a copy of the report?
Oh, yes, indeed. Under Madam Vice Chair, under both federal and state law, consumers are entitled to a copy of their consumer report anytime they want to, oftentimes for free. When a consumer report is used in an employment context, you are entitled to multiple copies before an adverse action is taken and after. In a landlord-tenant situation, same thing. You are entitled to a free report of your consumer report if you are in fact denied. And there's multiple opportunities if you're on public assistance, if you're unemployed, multiple opportunities for copies of your reports, and oftentimes for free. And there is an elaborate dispute resolution process established by federal law and by state law, and significant violations, penalties for violations of any of that.
But as a consumer, for me to get the report, I need to make the request. Is that correct?
Yeah, that's correct. Unless if you're denied, you are required by law to be given a notice that says, because of the action, because of the information provided by X, you are entitled to a copy of your report. You still have to request it for sure. Correct. Either on your own whenever you want to, or in an adverse action situation.
All right, but the landlord or the employer does not have an obligation to provide it to me.
That's correct. They are required to give you a notice.
Give me the notice, right?
Correct. That's correct. And it's up to you to request that report. Correct.
Okay.
That's
all right. That's helpful. Thank you.
Sure.
Delegate Crosby.
Thank you, Mr. Chair. I just kind of wanted to follow up with Mr. Ellman, and I think it would be Ms. Nelson that maybe could comment more on the preemption issue, because I'm looking at an OAG advice letter that says there's no preemption. So if Ms. Nelson could kind of counter that point, because I think you kind of spoke to it a little bit earlier, but if you could just clarify what Mr. Ellman says, and if you agree with the OAG's letter that there isn't a preemption issue, is my first question. Then I'll come back to my second question after you ask that.
Yes, Delegate, I'd be happy to do so. So we would disagree with Mr. Ellman and say that this bill would not be preempted. Under the preemption scheme under federal law is complicated. I'll grant you that. And one way that a bill could be preempted is that if the state law is inconsistent with federal law, which is what Mr. Ellman, I believe, or wrote in his, yes. So we would say that what is required under this bill is not in conflict with the maximum possible accuracy standard in federal law, but is in fact necessary to promote that. And without those procedures, you get errors and mismatching that you've heard all about. So we disagree that this state law would be in conflict with federal law.
Okay, thank you. And then my second question for Mr. Ellman is, like, you cited some statistics like you're 98% or you're 99.2% accurate. Do you realize how harmful when you're wrong that 1 or 2% of the time it could be? I mean, you have individuals living out of a truck because this is not an accurate report. And frankly, I kind of disagreed a little bit with Mr. Dunn, who's probably on the same side of the issue as me. He said it's kind of, you're going to need individuals, be a little bit labor intensive. But the reality is, having a computer background knowledge is that match system that you put it through, whatever that algorithm is, you could have computer programmers just plug in more data so that when you run the match, it's more accurate. And again, I think it goes back to Delegate Charkoudian's point of, you don't, just because you're asking for all this additional data that you wouldn't typically want to put on the report, just because you're using that to match who the individual is, doesn't mean it necessarily has to go onto the report in and of itself. So I just wanted to, get your take on, do you recognize how challenging it could be for some individuals who, if you're wrong, it's going to really hurt them?
Sure. Delegate, thank you for the question. Several questions in that, so let me respond a couple of ways. First, a 99.8% accuracy rate also means a 0.2% inaccuracy rate. And behind that 0.2% are real people with real problems and real stories. And it's unfortunate and it's troubling. Our members work as hard as we can to get to perfect. There's no perfect system for anything on earth. Hard as it is to get to perfect, we try every day. We are required by law to maintain accurate files, maintain reasonable procedures to assure accurate files, and we do the best we can. With regarding the matching, if you are asking for personal characteristics, you're asking those personal characteristics to show up on an application for a job or an apartment or for credit. And there are many cases where an employer, a landlord, or a lender does not want to, cannot, or should not put personal characteristics on a credit application, like race, for example, or sexual orientation. And we can't match a file with an application if there's no data on an application. And last point to your question, that's come up a couple of times. While well-intentioned, Social Security numbers and full dates of birth have been stripped out of public records. We would love for that information to come back for a specialized access, non-general public system. I was part of a committee established by the Uniform Law Commission, the ULC, to create model state legislation to improve the accuracy of public records at the source, meaning in the courthouse, in the sheriff's office, in the county police department, in the central repository. If we could find a way to work together to improve, if you're trying to address pollution, you address pollution at the factory. You don't do it downstream, although you can, but the best way to stop it is at the source. So if you want accurate public records, go to the source. We want to find a way to partner with the state to improve the public records in the courthouses, in the sheriffs, in the police, in the central repositories. That makes a better product for all of us, better than the 9.8% we're at now.
Thank you.
Delegate Charkoudian.
Thank you, Mr. Chair. In the case of Patrice and Patrick, was that an error that was made at the courthouse?
Yeah, I do not know the answer to that. I'm not familiar with the specifics of that case, Delegate.
I suspect that that was not an error that was made at the courthouse, because they were able to, this gentleman who just spoke was able to track it down and figure out that in fact the Patrice who was evicted, that was courthouse data he was able to find, was one person, and that was different than the Patrick who one of the companies that you're representing identified as having been evicted, and as such was living out of his truck. And so I guess, you know, it seems to me that you're asking to shift the costs. We're talking about costs, right? So we're talking about what you're able to, you know, where the profits are going, where the costs are going. And what you're saying is you want to be able to continue operating the way you're operating and shift the costs, add costs for the state. You want to add more costs for the state, right? Budgets are kind of tight right now. You don't want to make any changes in your operations. And so there's this shifting of the blame and shifting of the cost to the state. I mean, I guess that's your job to advocate for, but it doesn't seem like it solves the problem that seems to be in front of us. I don't know if you want to comment on that.
Yeah, Delegate, I'll take a run at that, because I know that you've been very focused in a number of your questions about costs and benefits and burdens and all of that. Our members receive compensation when they sell consumer reports to landlords, to employers. The Maryland state government, I don't know specifically about Maryland state government, but government agencies in general, federal, state, county, are often big consumers of our criminal and credit background check information. So the state and counties, I assume, are some of our customers as well. As the FTC said, there's a market incentive to maintain accurate files because our members compete on the data. That's what our members do. All we have to sell is the data. And if one company's data is 99.4%, a landlord or an employer might go to the company that's 99.8% because they're going to get.
How would they do that? How would the landlord find that out? I think this is where you have the information asymmetries that I was describing earlier.
Sure. Well, you know, if a landlord, for example, or an employer finds out that a smaller or a higher but overall small percentage of consumers have an error in their file, they will be able to address that with the agency that they deal with and march with their feet and go someplace else. So
do you know what the accuracy ratings are for the different agencies?
Well, you know, like I mentioned, as you've seen in my written testimony, we're talking about accuracy rates well above 99%.
Yeah.
And the other studies, independently verified studies, have shown accuracy rates in the 97, 98% as well. So in terms of accuracy, sure, there will be consumers who will have heartbreaking stories. We've seen that. We've heard some of that today. But 97, 98% is pretty good.
Okay.
And if we can work with the state to help improve that, we're all for it.
Yeah, I guess my concern is that you're all for it as long as it's the state that has to do something different, and you don't seem to be all for it if it's the companies that have to do something different.
We're living with all manner of new regulations right now.
Anyone else? Seeing none, let's go to our final witness.
Thank you, Mr. Chair.
Brent Smoyer.
Sorry, the mute button outsmarted me. Thank you, Mr. Chair, members of the committee. My name is Brent Smoyer, and I represent the Professional Background Screening Association, or PBSA. It's a trade organization of over 800 members across the nation, including many located in Maryland. I will sort of cut down my testimony just because I do believe Mr. DePietro and Mr. Ellman covered a great bulk of what we would have to say in regards to this bill. We would, of course, respectfully request that this bill not advance and that we have the time to work with the delegates to vastly improve what is a very well-intended bill, but I think would result in many unintended consequences. I think most notably it's worth pointing out again to really emphasize that this bill would hamstring, if not entirely prevent in some cases, the execution of responsible background checks. Most notably the requirement for either a full Social Security number or a full date of birth, which in 2021 is almost virtually impossible to acquire in a public record. It's rare for a CRA, a consumer reporting agency, to have access to even the last 4 digits of a Social Security number. And now jurisdictions across the nation are currently redacting full dates of birth down to simply a birth year, which you'd be shocked at the number of times that a full name and then a birth year should be enough, but it's not. Case in point, my unique name, Brent Smoyer, there actually is another Brent Smoyer located right now in Tennessee, who's a doctor, so clearly he was smarter than me. But the fact is we have the same year of birth, same first and last name, and so you would need greater information. And so we have been fighting for a long time to maintain access to CRA's full dates of birth and minimum last 4 digits of Social Security number. Now, this also includes pushes for greater uniform standards at the federal, state, and local level to ensure accuracy and accessibility, not just for our industry, but for greater collaboration between government agencies. I know we have worked with Mr. Ellman's organization, CDIA, to create what we have come to name the PASS standards, which is a universal document we are trying to share with courts and governments across the nation to try and bring those standards in line with very minimal cost, if any, in terms of trying to create these identifiers at a stronger, more accurate level so that we can use that in our reports and hopefully bump that 99% to 100% in many ways. Again, the final concern we would have that would really emphasize is a characteristic such as race, gender, ethnicity, as described in the bill. We just think it is a step backwards. We would like to try and avoid having that type of information put into place. And of course, I know Mr. Ellman mentioned the application process. There are situations and certain questions you are not allowed to ask that would fit this identifying situation. So I guess we're happy to work to retool this and to, of course, work on how we can improve accuracy both on our end and the end of government records with all of you. So thank you for your time.
Any questions for Mr. Smoyer? Seeing none. Thank you very much. That concludes the witness list for House Bill 642. That is the final bill of today. So I want to thank all the witnesses and the members for a good, productive day with the bill hearings. I know we got stuff tomorrow. We have bill hearings definitely tomorrow and Friday. Subcommittee chairs, you will be receiving notices about our meeting tomorrow. I believe it's noon, but I'm not certain. But we will be meeting tomorrow. And with that, everyone have a good evening.
Thank you.
Yeah. Good evening, guys. Thanks.
Thank you all. Take care.